Hi, good morning, everyone, and welcome to the free webinar today. And we will be discussing basic labor relations function. So let me just share with you my screen. Okay. Okay, and so I think we can start, no? We can proceed, but before we start our program for this morning, allow me to introduce myself to you. I'm Vivian. I will be the one to share with you my insights, my learnings, and experience as an HR practitioner for more than 25 years. No? So I'm also a certified global practitioner in HR by the UK Chartered Professionals in Human Resources. I'm also presently running a certification program in compensation and benefits as well. Likewise, I'm an accredited investors in people assessor and I've been in the HR practice for more than 25 years. So for this morning, no, for the 2-hour session that we will have, we will be focusing about employer-employee relationship and the different types of employees. A lot of times we are able to neglect the different type of employees that we hire in our business, so it would be good to identify them. And then of course a lot of us are engaged in terms of job contracting, so it would also be good to differentiate job contracting from labor only contracting, which is not allowed by the law, the labor only contracting. And of course we will refresh ourselves with regards to the ground for termination of employment, the concept of due process of law, and what does constitute unfair labor practice. Okay, and we will also be sharing to you my insights and experience about how to effectively manage employee discipline and at the same time okay, engage employees in terms of what we call positive workforce discipline. And what can I share with you in terms of my insights about labor trends or recent trends in labor management. Okay, so probably a lot of you have some familiarity or understanding about managing labor union as well. And probably a lot of you would ever think, why are there supervisors who are members of the union? And so therefore, okay, let us just qualify it that of course different organizations have their different definition and classification of people or talents within the organization according to the hierarchy in the organization. But under the Philippine labor law, when you talk about management personnel, okay, we will just be talking about two functions that they should be able to perform so that they would be classified as one. So under the legal context, okay, a manager is someone who has the ability to hire and fire. So if our supervisor, our frontline leaders don't have the authority to hire and fire, therefore they can claim that they are not considered members of the management team. So which is why you would also note that there are organizations wherein supervisors are entitled to overtime premium or to holiday premium, okay? Because they don't have this authority. Okay, but if your supervisors or if your frontline leaders have the authority to hire and fire, then therefore, okay, they are considered members of the management personnel. In essence, as a general rule, all members of the HR organization, so from the HR director down to the HR assistant, are considered management personnel. So therefore, we as leaders, we need to take note, what are the responsibility and the accountability of our people, of our leaders in the organization? Do they have the capability to hire and to fire? If the answer is yes, then under the Philippine labor law or under the legal context, they are considered management people. Okay, so what do we mean when you talk about employer-employee relationship? Because this is one thing that we will differentiate when you talk about job contracting. Because under the job contracting, okay, the company or your company doesn't have employer-employee relationship with the employee of your contractor. So what are the characteristics, no, or what are the guidelines that can outline us when we talk about employer-employee relationship? So there is an employer-employee relationship wherein or if no the company or the employer is engaged in the selection, okay, the hiring of their people. So if employer A, if company A, no, okay, is directly sourcing or not sourcing, hiring, okay, processing the assessment, and is responsible as to who would be the employee of the organization, then therefore they are considered employer, okay, of the said employee. They're also responsible for the payment of wages, okay. They have the power to dismiss or terminate employment, of course, for due cause or for authorized reason. And this is one important test, no, the control test. They have the control to which the employee would carry out the functions. Okay, the employer is also responsible to specify the methods, the standard of performance that needs to be accomplished. So the control test is normally the framework, no, or ito yung laging unang tinitingnan, okay, when you talk about employer-employee relationship. So, okay, so it's clear, no? So, for example, there are a lot of instances wherein you hire a manpower agency, no, or you request, okay, for a manpower agency or a supplier of labor, okay, to provide you with employee, and you're the one responsible in selecting who would be hired by the said contractor. So therefore, no, okay, that employee is your employee because you are the one selecting them. Okay, of course, if you're the one responsible, no, for paying the wages. And by the way, no, okay, the absence of a contract does not constitute, no, that there's no employer-employee relationship. So when you talk about contract, it's about the agreement of mind. So if we agree that I will hire you, okay, as an employee of XYZ company, and you will be receiving this salary, no, so therefore you are considered employee of the said company. Okay, so there are different types of employees. Of course, common to us, no, are the employees for regular employment, so which we call the regular employees. So they are the employees whom we hire to perform activities which are considered desirable and necessary for the business, no. So you hire them for an indefinite term. So they either separate employment for voluntary reasons or for authorized or for due causes. Of course, prior to regular employment, okay, you hire them as probationary employee, and probationary employment, no, okay, is for 6 months period. So after 6 months, 6 months plus 1 day, employees are already considered regular employees. So you can terminate employment for just causes or for failure of the employee to meet company standards. And of course, no, okay, the standard or performance must be communicated to the employee on probationary period. Can probationary employment be extended beyond 6 months? Yes, it can be, but there should be sufficient ground. So, for example, you are not able to um, assess, no, okay, well enough if the employee is suited for regular employment or not, no, and nanghihinayang tayo na kay i-terminate yung employment niya. So therefore, you would like to give them opportunity. So you can extend probationary period of employment, but no, employee must agree or must consent, no. Okay, then we have the so-called fixed term or temporary employees, or the project-based employees as you call them. You hire them for a specific or fixed term period. So for example, okay, they can perform functions which are desirable and necessary for the business as well, but only for a specific period of time. So in the construction industry, you would note, no, that they were high skilled workers at the construction site, but these are all coterminous with regards to the completion of the project, because again, you only need their employment for the time that you are constructing a specific site, no. So therefore, that's what you consider temporary employee. And then of course, you hire casual or seasonal employees. So for example, there are peak season in an organization, and that you have upsurge or a volume, so you hire them, no, to fill up a requirement. And normally, when you hire them, no, if you hire them for continuous 6 months, okay, they are considered regular employee as well. Or if it's a broken service, it's a total of 12 months period. So if you notice naman, no, sa mga retail industry natin, pagdating ng Christmas season, di ba, dumadami yung nakikita natin mga salespeople in the shop floor. So that would mean, no, that we are hiring seasonal employees, no, to augment the need of the business for a specific period of time only. Okay. So then we mentioned that we will be talking about job contracting. So in a job contracting, no, there are basically, okay, players. So there are three main players that are engaged in the contract. So these are the company, okay, the company that you represent, the contractor, okay, the company or the organization that you engage to render you the service, and the employee of the contractor who performed the service on behalf of the contractor, di ba? And this relationship is actually governed by the Department of Labor. So kaya although there are three major parties, no, so there is another party, no, who plays a critical role to the success of the relationship. So this is the DOLE. So you are guided, no, by the Department of Labor and Employment guidelines. So when you talk about contracting, so the company or the principal, so in this case you are the principal, you farm out or you outsource a specific service which is considered not necessary, not desirable, or not core, no, okay, within your organization for a definite or a predetermined period of time, no. And so when you talk about job contracting, no, so main essence here is that the service that you would like the contractor to perform is considered, no, okay, non-core part of the business. Okay, so but if you notice, no, a lot of activities are now being outsourced, no? And so therefore, what are the things that you need to check when you're looking for a job contractor? So when you're looking for a job contractor, okay, the contractor must have substantial capital and or investment. So therefore, they should be able to present to you, no, that they have relevant capital or assets or for the business to be able to carry out the business operations. Please be mindful of the amount, no, of capital or investment because it changes from time to time, no. Okay, so if you would notice, Supreme Court rulings or court rulings way back 1980s, you would see that it's about 1 million, that it becomes 3 million, and it becomes 5 million. Okay, then second, no? Okay, so the contractor is also compliant with the rights and benefits under the Philippine labor law. They should be, no, paying the right wages, no, the right wages. They should be paying the benefits, okay, and they should be remitting the benefits due to the employee, no, as prescribed by the law. So in this case, you can request your contractor to submit to you proof of payment that they submitted SSS remittance, PhilHealth remittance, to ensure that they are compliant with the provision of the law. Otherwise, no, if the employee file a case, even though there is no employer-employee relationship, there is what we call joint and solidary liability between the principal and the contractor. Okay, of course, the contractor is the one who manage the work or the service. They are the one, no, giving direction on how work will be carried out. While the standard of performance or the quality is prescribed by the principal, how it would be carried out will now be up to the contractor, no? Okay, so and therefore, the contractor also must carry a distinct and independent business. So, okay, so how it's being carried out, the tool and the trades to be used, no, is being managed by the job contractor. So, why are these requisites necessary, no? So this one, it's because we are trying to protect our employees, because one of the key rights we will be discussing later, one of the basic rights of a Filipino employee, no, is the security of tenure. So which is why we are trying to differentiate job contracting between labor-only contracting. And labor-only contracting is not prohibited. It's prohibited, sorry, no, this is not allowed by law. So when you talk about labor only contracting, so these are the some of the red flags, no? If the alleged contractor don't have substantial capital or investment, so therefore they may be engaged in labor-only contracting. If they merely provide you labor and you are the one, and the principal is the one directing how things would be carried out, you are the one providing them the tools, the trades that are needed to carry out the function, then it may be considered labor-only contracting. If they are performing no functions which are necessary or desirable to the business operations, then it can be classified as a labor only contracting, although it's a very gray area, no? So which is why when you consider a particular operation of the business not core or not necessary and desirable, you should be able to provide indicators or guidelines, no? And okay, if the principal is the one, no, okay, specifying how work would be done, or they have the right to control over the performance of the employee, then it's labor only contracting. And in labor only contracting, as we are all aware, the employee is not the employee of the contractor, but the employee is the employee of the principal. So, which is why no, we have to be very careful when we are engaging in job contracting, because sometimes, no, especially our frontline leaders, we need to ensure that our frontline leaders understand no the concept of job contracting, because there are times no okay with the urge to get things done, yung ating mga frontline leaders, sila na yung uutos, sila na nagsasabi kung paano gagawin, and sila na rin yung nagsusupervise every step of the way in terms of how things should be carried out. So be mindful of that, no, because we may be bordering no what we call labor only contracting. As I've mentioned to you, hey, all of this, no, okay, are set by the government, or set by the government to protect the rights of our employees. And let us, while I understand for most of you are already familiar with the rights of employees, no, it would be good as well to review and refresh ourselves. So no employee in the Philippines can be dismissed without cause, either through authorized causes or just causes. Hindi uso sa atin yung tinatawag na employment at will. Ano yung employment at will? Ay, naku Pedro, ayoko na makita yung mukha mo tomorrow, wag ka nang pumasok. Cannot be done in the Philippines, because in the Philippines, we protect security of tenure. We guarantee security of tenure to our employees, no? Okay, and we will be discussing later what do we mean by authorized causes and just causes. Okay, of course, the security of tenure is also severe when the employee voluntarily resigns, no? And of course, when an employee is work for more than 6 months of probation, di ba? 6 months plus 1 day, they are considered regular employees unless you extend the probationary period of employment and it has an employee consent. Okay, then the normal hours of work is 48 hours a week. Okay, nauso na sa atin ang compressed work week. So the compressed work week is actually allowed by the Department of Labor, because in the compressed work week setup, it's a win-win situation between the company and the employee, di ba? Wherein you consume the 48 hours work week in a matter of 5 days, or yung iba nga 4 days, and then you give employees more time for rest days, no? If the meal break is less than 1 hour, then it's considered a paid break. Kaya yung mga manufacturing company natin, no, na nag-extend ng 30 minutes meal break to their employees, that meal break is considered paid, no? Okay, and part of the regular working hours of the employee. And sabi nga natin, employees are also entitled to their weekly rest day. So, yan, paano yung tinatawag natin na, let's say, paano yung tinatawag natin na kung naka-compress work week, walang definite na schedule ng rest day. So, it's still considered for as long as, no, okay, employees are given time to rest, no, okay, for at least 8 hours on the average per week. Then, of course, they are entitled to wage and wage-related benefits. So, we have minimum wage rate per region, and you need to be mindful of that, no? And whenever there is change in the minimum wage rate, okay, so you need to follow a distortion formula if you are paying your employees via the minimum wage rate. They're also entitled to the regular holiday pay, no? And of course, premium pay for work that is performed during holiday and rest day. So, I will not be outlining everything, no, because I know you are already familiar of what are the wage and the wage related benefit. Then we're also extending service incentive leave of 5 days with pay for every year of service, no. Okay, so if the company is providing already vacation leave, no, the 5 days service incentive leaves is already forfeited, no, or sabi nga natin, kung tayo ay binibigay na VL and SL, the company policy now governs, no? When it talk about conversion or when you talk about accumulation of leaves. And then, of course, no, employees are entitled to 13th month pay as well. By the way, even though you terminate employee for due cause, no, employee terminated even for due cause are entitled to the pro rata equivalent of their 13th month pay and service incentive leave. Okay, of course you're also entitled to a paternity leave, no, if you become a new father. Okay, of course, we now have the special leave benefits for women under the Magna Carta for women, no? And we have the 105 days of maternity leave benefit as well. Then right now, no, meron na rin tayong tinatawag na 10 days of leave, no, special leave for employees, no, who are victim of violence against women, no. So you need to make mindful of that, and that's 10 days for every incident, no. Okay, and then people are entitled to separation pay based on authorized causes and retirement benefit upon reaching the age of retirement, no. So it's 60 years, yun yung optional, no. 60 years of service with 60 years of age with at least 5 years in service. And then, sabi nga natin, employees are entitled to payment of wages. Hindi pwedeng, wala naman tayong kontrata, 2 araw ka lang namang nag-work, tawad na yon. Hindi po pwede yon, no? So there is no such thing as slavery and in the concept of the Philippine labor law. Okay, and then the employment of young workers is now at 18 years of age. In the past kasi, it's 16. Then it was upgraded to 18 years of age. But I also would like you to be mindful, no? Because under the International Labor Organization, there are certain establishments wherein the minimum age of employees must be 21 years of age. I came from the hospitality industry before, no? We operate and manage cruise lines, and in the cruise lines, if you are, though we in the cruise lines industry, if you are serving alcoholic beverages, then you should be at least 21 years of age. So please be mindful that aside from the Philippine labor law, no, if you are governed by the international law, you need to observe by the rules as well. Of course, no, it is also a responsibility to make sure that we provide safe and health conditions of work, okay, to our employees. And sabi ko nga, di ba, the conditions of work already have changed. Yung concept ng safe and healthy, hindi na lang siya physical, no? It already involves mental wellness as well. Then our employees have the right to organize themselves and to collectively bargain. Even in the absence of a union, our employees can collectively organize themselves, no, and they can approach leadership and say, 5 years na po kaming walang increase, we would like to bargain, and we cannot shrug it off and tell them na, uy, magtayo muna kayo ng union bago tayo mag-negotiate, no, because employees have the right to self-organize and collectively bargain. And of course, no, they also have the right to hold peaceful concerted activities, no, which is in the manner of law for as long as hindi sila nakakaistorbo, no? Okay, with regards to the peace. Employees also have the right to educate themselves with regards to their rights. Kaya I suggest, no, you also reach out to the Department of Labor and Employment within your area, collaborate with them and check how you can run an orientation program, no, okay, with regards to employees' rights, no. And my experience working with the Department of Labor and Employment have been very fruitful. Kasi syempre mas maganda kasi third party sila. Although tayo alam din natin ito as HR practitioners, 'di ba? Pero sasabihin ay self-serving kasi yung company. Pero 'di ba, pag if it's a third party, especially if it's Department of Labor, okay, so naniniwala agad sila. And my experience working with them are very fruitful and insightful. They help, no? I have an experience in the past, no, wherein may mga misconception yung aming mga employees in terms dun sa kanilang mga benefits. And the Department of Labor help them understand, no, that the organization is actually giving them more than what is provided for by the law. As well, no, they have the right to access court and quasi-judicial body. Kaya hindi nyo sila pwedeng bawalan kaya na pumunta sa NLRC or sa DOLE para mag-file ng complaint against the organization, no? So this is part of the employee's right. Of course, as we also have shared, no, they are entitled to the ECC benefits, the employees compensation, the SSS, the Social Security benefit, the PhilHealth, the HDMF, no. So these are the mandatory benefits that you are familiar with already. Okay, and sabi natin, no, okay, there is a so-called unfair labor practice. Pag sinasabing unfair labor practice, no, this pertains to the violation of the right of the employees to self-organize. So if you are prohibiting employees to organize themselves, to collectively bargain, they can charge you with ULP. So pagka naman kayo ay unionized organization, 'di ba? They can also charge you unfair labor practices if the union felt, no, that you are hindering their rights to collectively organize themselves. Okay. So, the elements of the unfair labor practice, sabi nga natin, no, it actually boils down for me in the attempt of the organization to prevent employees from exercising their rights, no? Okay, to form a union or to organize themselves. Okay, because at the end of the day, the employee naman would be the one to select, no, if they would like to form a union or if they would like to organize themselves or they would like to collectively bargain. Later on, I will be discussing with you I will not consider it as a recent trend, but it's even a practice that the Department of Labor is encouraging already. The formation of Labor Management Council, even though you are not unionized. It started with an organized setup, no? So yung mga unionized organization or organized setup, meron silang mga tinatawag na Labor Management Council. So this practice was encouraged by the Department of Labor to be adapted, no? Okay, even though you are not a unionized organization. In the Labor Management Council, you select or you appoint or you let employees elect representatives from the different department. And there will also be representatives from your frontline leadership, mid-level management team, no? And they form a council wherein they take care of the employees' welfare. They also very mindful of what are the things that cause employees pain points and how they would be able to help the leadership, okay, so that they would be able to reduce the employees' pain points. Sabi ko, hindi na siya trend because I was exposed to LMC even way back in 2005, no? One of the organization I've been with, hindi pa siya pinopromote ng Department of Labor. Meron na kaming Labor Management Council. And sa totoo lang, no, napakalaki na naitulong niya sa HR. Kasi katulong sila ng HR hindi lang sa mga events, pati dun sa pagmamanage ng mga employee welfare activities, no? Sila rin yung nagsasabi kung ano yung mga concerns na naririnig nila sa baba, no? Dun sa ating shop floor, dun sa ating mga employees, and tumutulong sila, okay, sa HR, sa management team sa pag-resolve ng mga issues, no? Okay, so therefore it's a trend or it's a best practice that you may want to adapt, no? And in fact, when you are being audited by DOLE, they will also encourage you to form one. Sabi natin, no? Employee separation. So what are the different types of employee separation? So, okay, employee can terminate their employment with the organization. So unless otherwise is specified in the contract, so you have to notify your employer 30 days in advance or 1 month in advance. Ito yung 30-day notice period pag tayo ay nagre-resign as an employee. Okay, but so nag-resign yung employee namin 30 days. Pwede ba yon na i-effect ko na agad a week from now? Pwede naman, no? So, ang sinasabi natin, it's the employee. So that there should be proper handover and there is opportunity for the employer to find a replacement. Merong mga may mga positions wherein no nakalagay sa kanilang contract of employment is 60 days because these are considered hard to find jobs. So in that particular case, we need to observe the 60 days period. However, there are instances no wherein the notice period is waived. So kailan yon? If the employer insult no or threaten or humiliate or degrade their employee, no? If there is inhumane treatment or if there's a commission of the crime. So meaning, no, yung employee can choose not to report to work anymore if they felt that they are serious, that there is a physical, no, threat, they are verbally abused, no, or they are threatened by their employers, no? So if it's employer-initiated naman, we classified it into two, the authorized causes and the just causes. So then let's talk about first authorized causes. Pag pinabi nating authorized causes, the employee is not at fault. So walang gidawang violation or infraction si employee. So the authorized causes no can be due to installation of labor savings device, redundancy, retrenchment, closure of business operation, no? So these are the reasons no for authorized causes. So in this particular cases no when you talk about reduction of people, lagi kong sinasabi no, it would be good to have criteria in terms of selecting who are the people that would be affected, okay, so that you are objective in terms of managing no the separation process. You also need to be mindful no of the prerequisites. You need to notify the Department of Labor at least 30 days prior to the effective date of the termination. So even if you don't require the employee to report for work already, so for example, you hand over the employee separation, it is effective end of January 31, but you told the employee you can opt not to report for work anymore, then you need to pay the 30-day notice, no? Okay, then of course, you need to pay the employee a separation pay. There are certain companies who have guidelines when it comes to separation pay. So if meron kayong guidelines that you observe, no, okay, you need to take note of your guidelines or the Philippine Labor Law guidelines and check which one is superior. So if whichever is superior, that is the one to be applied to the employee. Ngayon, kung wala naman, then you are covered by the Philippine Labor Law when you talk about guidelines for computing separation of employment. So be mindful, pag nag-open kayo ng same position within a year, no? Okay, so yung employee natin have the right no to be prioritized for rehiring. So kaya yun yung tinatawag nating 12-month period. Okay, then sabi nga natin, no, ito yung computation na ginagawa natin or ginagamit natin when we talk about authorized causes, no? Kaya kailangan lang ma-distinguish natin. Kaya bakit mas mababa ang retrenchment and cessation of business operations? Kasi ang reason for retrenchment or reduction of people is because you are trying to prevent or meron ng losses na nangyayari sa business. Kaya no, yung separation in pay entitlement nila is lower compared to redundancy or installation of labor saving device, no? Okay. So I just would like to share with you my experience no when you talk about authorized causes of separation. So you also need to be mindful that it is very important for people to understand the reason for the separation, that it is a business decision. It's not an easy conversation. You cannot just tell people, "Or we're losing money, then we need to let you go." You need to let them know as well, no, that the company also have tried their best, to augment for the losses, and the separation of employment is the solution that they are seeing right now to prevent further losses, no? And people already understand, nakikita naman ng mga tao natin yan, no? If the business is really losing money or if there's already hiccup, no? And what is important is we also listen to their concerns, no? Okay, so listen to their concerns and try to check how you can not necessarily eliminate but at least reduce the employees pain points, no? So can you offer outplacement services, can you offer program for livelihood or investments, no? Kasi syempre kailangan ng guidance ng mga employees din natin, no? And let them feel no that you are with them throughout the process. It would be good as well, no, to speak to them individually, because individually they have their own personal concerns that they may want to bring out to you, no, and you may want to um, listen to them. Minsan hindi naman natin kayang sagutin agad-agad yung kanilang mga concerns, and it's okay, no, we can always let them know that we'll get back to them, and but it is more important that we also get back to them, no, so that they would know that we are honoring our commitment to our employees. So in terms of authorized causes, no, for me it's really a matter of showing empathy, okay, hearing them out and trying to provide necessary intervention which is within our control. Okay, then you also need to take note, no, that is a ground for termination. So we have employees, no, who cannot continue to report for work anymore, no, because they are suffering from a disease, no, okay, and they can apply for medical retirement. This is what we call it, no. But in medical retirement, no, what you need to take note is that there should be a certification coming from a government physician. So hindi yung ating mga accredited company physician. It's a government physician that should certify that employee cannot, no, dispense regular function so that they would be entitled to medical retirement. Okay? So and of course, as I mentioned to you, no, syempre our priority is the health and welfare of the employee. So if you can extend to them your HMO even for a limited period of time, no, so that they can transition, if you can also help them out in terms of their social security benefits, no, kasi meron naman provision ang SSS with regards to partial disability or permanent disability, then it can be a lot of help to the employee, no. So in this manner, no, what we need to highlight is that the employee's health, no, is our primary concern, and their continuous reporting for work, no, or exposure can actually mean more harm to them, no. So they need to recuperate, and so therefore, okay, you can subject them to medical retirement. Of course, no, we also have the just causes. So the just causes, this includes the actually, no, ito yung sinasabi nating other causes analogous to the foregoing, is what was indicated, or what are those violations indicated in your employee code of conduct. But if you don't have an employee code of conduct, you need to follow what is provided for by the Philippine labor law, okay, which are as follow: if there are serious misconduct or willful disobedience, gross and habitual neglect, fraud or willful breach, no, and commission of a crime. If it's a management personnel, so the breach of trust, no, by the employer also plays a very important role. But in this particular um, in this particular separation from employment, no, you need to observe due process. And when employee is terminated for just causes or due cause, as we are famous, as we commonly say it, no, employees are not entitled to separation pay. Para lang yan pag nag-resign sila. They are not also entitled to separation pay unless otherwise may company policy, no? Okay, and of course, the company sponsored benefit kay employer, the employer can opt not to extend it as well, no. So ang mandatory lang yung ibibigay, which is the pro rata equivalent of the 13th month pay and the service incentive leave. So what do we mean by due process, no? Pag sinabi natin due process, 'di ba, this is the disciplinary process that we accord to the employee, and it consists of the employee's right to know what is the allegation or what is the alleged infraction or alleged violation, and that he is given opportunity to be heard and be provided with an objective trial. So you always have heard of the twin notice rule. Under the twin notice rule, the employee has the right, no, okay, to be informed, no, what is the allegation. Okay? And what would be the penalty? So what I always tell, no, may mga employee infraction tayo. Nakalagay sa employee code of conduct ninyo. Okay, penalty if proven correct. Okay, 3 days suspension to 7 days suspension. Okay, it would be good to indicate it in your notice to explain so that your employee would know what would be the maximum penalty if they are found guilty of committing an offense. By the way, pag nilagay natin 3 to 5 days of suspension, you cannot go beyond the 5-day suspension or the maximum penalty that you have specified. Of course, part of the twin notice rule, no, is that you need to subsequently advise the employee of the decision. What is the notice of decision? A lot of times the employer, pagka wala namang kasalanan yung employee, hindi na nagbibigay ng notice of decision. You also need to provide notice of decision or clearance to to take note that the employee is cleared of that said offense. Okay, it is will also be good so that employee will have peace of mind as well. Employee as well have the right to represent themselves. So they can appoint someone to represent themselves. They can appoint a legal counsel. Yes. Okay. So if they feel like they can be better represented by a legal counsel, yes, they can do that. Okay. They have the right to explain, which is why you need to encourage employees to respond to notice to explain. Okay? Because kahit hindi naman sila mag-respond, pwede pa rin naman nating ituloy yung ating investigation. At sabi natin, pag sinabi nating fair treatment, we conduct investigation. And what I always inform is that if you do administrative inquiry, is for the employee to hear what others have said, and so that he would be given opportunity to clarify. So, when you talk about due process, I would like to share with you what I always do in the past. So, first inform the employee of what the violation. So, you have heard about the violation. You conduct initial investigation first. Huwag tayo issue ng notice to explain. Kasi baka maturete naman yung mga employees natin. So, conduct initial investigation, and if you find there is a probable cause, then that's the time that you issue notice to explain. Okay, so then when you receive the letter of explanation from the employee, you check and evaluate the explanation presented. You can opt not to conduct administrative inquiry, but what I did in the past, if it involves suspension of more than 1 week, because it affects livelihood already, it has negative impact on the livelihood, medyo significant na, I always conduct administrative inquiry. Okay, and from the administrative inquiry, then that's the time that we assess, we evaluate, and we come up with a decision, and we inform the employee of the decision and the action. Madami sa atin is nagbibigay ng suspension tapos ini-staggered natin kasi makaka-paralyze daw ng business operation. So, hindi rin nagiging impactful yung ginagawa nating punitive approach. So, when you implement suspension, ang suggestion ko is to always implement it one time, hindi staggered. Kasi pag staggered, hindi yung suspension, vacation ang tawag natin doon. So, in the notice to explain, it would be good to make sure that in the notice, there is the alleged violation of the rules. Ano bang violation ng Code of Conduct or ng Philippine Labor Law ang binaviolate or allegedly binaviolate ng ating employee? Ilagay natin yung narrative ng incident para alam nila kung ano yung particular incident na pinag-uusapan natin. What is the potential consequences pag napatunayan tama? So this is yung penalty na sinasabi natin. Bigyan natin sila ng sufficient time to explain. It's 5 calendar days, And kung magpe-preventive suspension tayo, so mas magandang ilagay na natin agad kung sila ay naka-preventive suspension. And of course, we have to advise employee that they also have the right to be represented. So yung preventive suspension is not more than 30 days, without pay. And you normally give preventive suspension if the continuous presence of the employee pose danger to the company or to other employees, So can you extend? Yes, but beyond 30 days, it's with pay already, Okay, and if the employee is found not to violate any infraction, then the preventive suspension would be paid. So in the administrative inquiry, as I always mention to you, Okay, so you need to notify the employee in advance kung kailan yung inyong administrative inquiry. So ngayon, pwede na rin itong gawing online. Okay, so you just need to present to them, the link. So Google Meet, Zoom, kung ano yung link ang gagamitin natin, Okay, and at the same time, what would be the stand of the management if the employee will not attend the administrative inquiry? Itutuloy nyo ba or i-allow nyo siya? It's also be good, kung pag kayo ay magkakaroon ng administrative inquiry, Okay? At gusto nyong i-record, wag nang magtaduguan. Okay? Humingi ng permiso ha na i-record ninyo yung proceeding. At pag nagbigay ng permit no or ng permission, kung pwede agree to everyone na tayo ay magre-record, that's the time that we can record. Of course, no, in the administrative inquiry, the facilitator or the presiding officer no need to reiterate as to why you are there, why you are conducting the inquiry. Okay, sabi ng iba, ah, paulit-ulit naman kailangang banggitin ano yung allegation, ano yung maximum penalty. Yes, it is necessary. It's also good to set the norms, no, para maiwasan natin yung chaos during administrative inquiry. And let's focus on the facts, on the acts that are committed on the facts at hand, no? Okay, and then summarize the discussion, and if there will be continuity of the meeting, kailan pa yung sunod na meeting para alam na ng lahat, and the minutes of the meeting must be signed. It would also be good to create a norm, okay, when it comes to signing of the minutes of the meeting, no? Okay, and then of course you need to inform the employee of your decision so that it would be clear to them, no? Okay, and what would be the basis for making the decision. And the effectivity must be immediate. So kung ito nga yung sinasabi ko, kung sususpend nyo, immediate. Kung ito terminate natin, immediate din yung termination. Okay, and then, no, sabi nga natin, okay, pag ba violation of or company infraction, kailangan ba there's a proof beyond reasonable doubt that an employee committed an offense para ma-terminate natin for employment? Is substantial evidence part of due process? The answer is no. Okay? Because unlike criminal case or civil case, circumstantial evidence will suffice when you talk about employee separation. Okay? But of course, when you talk about due process, there are mitigating and aggravating circumstances that you need to be to note of, no? Sabi natin, ano ba yung mitigating and aggravating circumstances? So sabi natin, mitigating circumstances, no? Okay, ano ba yung mga circumstances or behaviors niya na pwedeng makapagpagaan, no? So, nung kanyang offenses. So, halimbawa, this person has been a good performer, a high performer in the past. Or, naku, talaga namang nagkaroon ng negligence pero hindi talaga malaki yung cause pero talagang based on investigation hindi intentional, no? So wala talaga sa loob niya, hindi niya alam. Okay, so those can be mitigating circumstances. Ano naman yung aggravating? Ito yung mas nakakabigat, no? So halimbawa known na siya na talaga namang siya ay lagi may nakikipag-away sa shop floor, no? Or lagi siyang or talagang it was deliberately done by the employee. So those are aggravating circumstances as well. Okay. So when you talk about due process, no, my advice is to ensure that our frontline leaders are familiar with the due process of law, and they should be able to manage what we call the employee disciplinary process. So in the employee disciplinary process, ang maganda sanang partnership is that if it's our frontline leaders who is conducting the disciplinary process, and HR act as their consultant. So HR works with them so that you can strike a balance. Kasi sabi nga natin, objective and fair treatment, no? So which is why it is I highly recommend for your leaders to make sure that they are familiar as well with the due process of law and how it is being carried out. Okay, sabi natin, one of the things that are because I work with multinational organizations, and we have quite a number of foreign talents as stakeholders, they always mention that they have an impression that the Philippines is a country which is rigid when you talk about rights of employees. So as I mentioned to you, we already have discussed the rights of the employees, and sabi nga natin, how do you want to say this glass of water? Half empty or half full? And I always would like to see it as half full. So unlike yung sinasabi, na-discuss na natin yung employee rights. So yung lahat ng hindi part ng employee rights, ang tawag natin doon, management prerogative. No, so what are our management prerogatives? So we are the one to determine the direction and the conduct of the business. Saan tayo pupunta? Okay? Ano yung mga kailangan natin? Tayo rin yung nagde-determine ano yung criteria or standards na hinahanap natin when we hire people, when we select people. Okay, we are the one in charge of assigning their work, how it's being carried out, okay, and the time and the place of work. Okay? We also provide them no with a methodology. Sabi natin, oh, ang gamitin mo itong SAP, hindi nila pwedeng sabihin, ay ayoko po niyan, bumili po kayo ng Oracle. No, it cannot be done, no? They need to adhere to our standards and even to in terms of the way we would like the process to be observed in the shop floor. We can also transfer our employees no from one place to another. Okay? And of course, setting performance standards, which is why I always highlight that yung iba sa atin, regular na yung employee, tsaka sinasabi ano yung performance standard. Mas maganda kung sa first week of orientation, alam na ng employee ano yung kanilang mga performance goal. Okay, the work regulations, the company policies, and what are the grounds for discipline, dismissal, and layoff. Sabi nga natin, no, management prerogative must be executed in good faith and for valid business reason. So, pwede naman tayo mag-change ng ating policy. Pwede tayong mag-change ng ating procedures for as long as it's done in good faith and with business reasons. No? So, can we restrict management prerogative? Pwede ba? Pwede. If we indicate it as part of our contractual limitation and legal limitation. One client of mine, no, sabi niyo, management prerogative natin is we can transfer people. Bakit itong mga employee ko, hindi ko may transfer ng work assignment? When I review the contract of employment, it specifically indicates that employee can only be transferred, okay, to an area or to another location subject to his or her approval. So therefore, no, nilimit niya yung kanyang contract, yung kanyang prerogative. Second, no, if you are an organized company, no, so and you would like to note or you just came or you just culminated your CBA, no. So normally the CBA would specify what are the benefits extended to the union, but how it would be implemented, it's still part of the management prerogative. But if you encourage the union officers to join you in drafting it, then you are also already restricting your management prerogative. Okay, sabi ko kanina, no, I would like to share with you a more proactive approach when you talk about employee discipline. And I would like to share with you the concept of counseling. So when you talk about counseling, no, you may want to take note, no, that if you already notice a negative behavior, kahit wala pang violation or violation of company rules and regulations, you may want to subject your employee to counseling already. So in counseling, you are already calling the attention, you focus on the facts, the incidents or the action, and how the incident or action, okay, can lead no to violation of company rules or employee disciplinary action. And you can already check no or help the employees. Sabi ko nga, para kayo nag-root cause analysis dito. You help the employees analyze no, okay, what is the root causes for the negative behavior, and you help them to be able to recover or to correct the behavior, reform. Okay, and no, sabi nga natin is ask the employees the support, okay, that they need from you so that they would be able to, sabi nga natin, reform the negative behavior and be able to perform better. So you may want to check on counseling. Of course, hindi naman lahat ng infraction counseling, di ba? Kung grave na, baka yung counseling is not applicable anymore. And of course, when you already have done 3 counseling sessions, no, and wala pa rin nangyayari, then it may be the next decision no is to escalate no or to consider employee disciplinary process as well, because employee discipline or self-discipline is also part of our mantra as leaders, no, to embed self-discipline. So I just would like to share with you some of my insights when you talk about due process. First is focus on the acts and not on the person, no. So sabi ko nga, no, when you talk about the person, you, no, they become more defensive. Okay, so when you focus on the act committed, then they are able to distinguish that you are not against them as a person, but you are not tolerating the behavior that was exuded. Okay, then if you can turn the disciplinary action, okay, process into a coaching or counseling session, that would be great. Then, of course, you need to observe respect and due process at all times, even when you are doing administrative inquiry, no? And you need to make sure that your policies are aligned to your company values. Kasi um, when you give the employee a book, no, a 60-page book or a 20-page book about your code of discipline, ang hirap nila yung matandaan or ma-memorize. Okay? But if you have company values and your company policies are aligned with your company values, alam agad ng employee natin what is right and what is wrong. What is allowed by the company and what is not allowed by the company. And it will help them make the right decision. Okay? Then sabi nga natin, no, may experience managing a shared service organization, no? The employees can avail of the quasi-judicial or the court, di ba, services. So, okay, if it's a non-unionized organization, so the dispute is being settled at the NLRC. So, yung tinatawag nating SENA conference. So, there is a mediation process. Dati, 3 times. Ngayon, twice na lang, no? Pag hindi kayo nagkasundo twice, then you will now be requested to submit a position paper. And that will now be heard by NLRC. And of course, you can file an appeal. Sa first level is the NLRC. Muna uli, no? And then, pagka nagkaroon pa rin ng appeal, it will be escalated hanggang makarating sa Supreme Court. So sa Supreme Court, pag nasa Supreme Court na, no, so magkakaroon ng ruling, and those Supreme Court rulings, no, okay, are all embedded, no, dun sa kanilang mga dun sa kanilang book, no, na ginagamit naman ng ating mga labor arbiters or labor lawyers when it comes to their decision making as well. If it's a non-unionized proceeding, no? So sinisettle muna ito through the employee grievance process. At pag hindi na siya ma-settle through the employee grievance process, that's the time that they subject it to the mediation process or they subject it to NCMB. So lahat ng issues about unionized or organized, no, or set up is being managed by NCMB. Okay. So again, no, so in the mediation process, so we need to make sure that we comply to the legal proceedings, no? So we are open. Sabi ko nga, no, pagka alam naman ng company na mali tayo, then let's open ourselves to a dialogue and how to correct it, no? Okay, but ako rin naman, ang lagi kong advice, pag alam natin na tama yung ating decision, let us also be firm. Okay, otherwise, no, we will be creating mixed signals to our employees. And of course, when you talk about managing employee complaints, eto, kasi sabi natin, puro tayo employee discipline. Paano naman pag may reklamo yung mga employee natin? Anong gagawin natin? So you may want to consider as well creating an employee complaint process. So employees may have concerns against their immediate superior, a member of the management team, a peer of them, no, yung kulig nila. May sa akong client, no, yung mga reklamo daw nila sa HR is really more about yung mga kasama sa trabaho, yung pagiging noisy, no, yung parang nakaka-disturb na, and of course the working conditions. So it would be good, no, okay, to hear them out as well. So which is why it would be good for HR or for the leadership team to create an open door policy. Kaya nga part of it, no, is to make sure that we reach out to people, okay, so that we would be able to understand. Dati-dati, no, siguro mga about 15 years ago, okay, HR adheres to employee complaint pagka nakasulat. Pag hindi nakasulat, hindi ko ni-consider na HR, no, na complaint. But sabi nga natin, no, through time, we already realized, no, that we should be able to hear out the concerns of our people. So kahit ito ay sabi nga natin, no, verbal, we hear them out, we ask for more information, and then we try to understand the employee perspective, we show empathy, no, and then we check the company policy. If it's something na nakita natin na meron infraction or meron ng violation, then okay, we correct it, or if na naman, then we clarify it to the employee. But we need to make sure, no, that we make the employee know na we are acting on their complaints. So ngayon, usong-uso ngayon, no, yung sinasabi nating bullying. Okay? And so In the case of bullying, it would be good if the employee have an employee complaint machinery. And what I've always done, no, is that most of the time, no, they go to the person who they feel comfortable sharing. And so kung sino man in the leadership team na comfortable sila, no, okay, we always tell the members of the leadership group, no, to make sure that it's communicated and it's addressed properly. At kung hindi naman within the capability, no, of the leader to manage, kasi sabihin na natin, no, hindi natin alam paano natin i-manage, it would be good to direct them to the right party who can help them out so that their issues would be resolved. Employee can also complain, okay, about yung kanilang result ng disciplinary process, no? So which is why it would also be good to come up with the escalation, okay, the escalation process until it comes, okay, to the highest level. Siguro naman from the supervisor to the head of the business unit, mare-resolve natin yung ating mga problema bago lumabas sa arbitration. Actually, I also would like to encourage you, if you are not unionized, to have an employee complaint process if employees are not satisfied or they feel na hindi nagkaroon ng fair treatment dun sa employee disciplinary process. So, ang maganda dito, no, is that if you have a documented process or institutionalized process, alam ng employees natin yung next steps, no? So, hindi sila agad pupunta sa NLRC because they feel aggrieved. They know that the company has a mechanism to support them, no? Until such time that their issues is resolved or clarified, no? Okay, so in the end, no, what I would like to share is that the leaders and the employees coexist to attain the organization's vision. If you are an organized setup, no, in a unionized environment, treat the union that they are employees, no, hindi kayo magkaaway. Okay, kayo ay pare-parehong employees ng company, and hindi na uso ngayon yung taguan. Kailangan we are transparent because we are partners, no, to achieve the organization's vision. The members of the union and employees as well, they also mean well, no, with regards to the company. So if they understand the company's direction, of course they will support us as well so that we can attain our objectives, no. If you are not a unionized organization, okay, so open the door to your employees so that you will be able to hear them out, no, to listen to the employees' pain points and be able to adjust, no, or if hindi naman natin kaya masolusyonan lahat, but at least minimize the employees' pain points or explain to them, no, the reasons or clarify to them so that they would understand. There are incidents in the past, no, in my previous career na hindi agad hindi ano, parang naiintindihan nila bakit hindi sila puwedeng pagbigyan ng leadership team. Sasamaan loob nila, 'no, okey lang 'yun, okay. And then sooner they will understand, no, that we only mean well, that we need to be objective, and they will understand and they will support and they will accept the decisions of the leadership group, no. Okay, and that would be the end of my conversation this morning to you. And I think we can now open the floor for some questions if there are any. So please feel free to chat, to send us your questions or your comments in the chat box, no? Yan. And allow me to read it. Okay, hi, good morning, everyone. Some of the people in the room are known to me. So, hi, good morning. How are you? And Happy New Year to everyone now. So, when it comes to pay rules for regular employees, there are laws that that they should be monthly paid. I can't find anything on the labor load. Okay. Um, hindi naman porke regular employee should be monthly paid. So normally, when you look into the concept of the law, so there are daily wage earners or there are monthly paid earners, no? So in other organizations I've been with, okay, so we have the so-called yung mga nasa business manufacturing operations namin, they are considered daily wage earner kasi variable pay ang konsepto. And then sa fixed term naman, they are monthly paid. So, there's no clear guidelines na pagka regular employee ay kailangang monthly wage. So pwede pa rin silang daily wage, no? So it's part of management prerogative. Yes, you are correct. Are there dole requirements before allowing the company to retrench mass layoff? First, you need to notify the Department of Labor the reason for retrenchment. Of course, it would be good na, syempre, para hindi na tayo hingan ng mga documents if we can already provide no certain documentation for certain information as to why we are retrenching. So for example, due to the pandemic, alam naman natin no madaming negosyo na nagsuffer, so inilalagay nila yung reason no na hindi pa sila nakaka-recover, so therefore they don't see any other option but to reduce their people. So nilalagay nila yon, and then meron tayong DOLE termination report that we need to accomplish na isusulat natin doon who are the people affected. Okay. And then mas maganda rin kung maisulat natin kung ano yung ating grounds or selection. Kasi halimbawa kung 50% reduction or 20% reduction, so paano mo pinili yung 20%? Para mas okay din sa mga tao natin pag kinausap nila, natin sila as to why they are the ones selected. Is it okay to have both? To have the 5 days SIL and the VL and SL? Yeah, it's part naman of your prerogative, pero nakikita kong experience is pag may VL tapos may SL, wala na silang SIL. Inilalagay na nila doon because normally SIL, ang counterpart kasi niyan is the vacation leave eh. Ngayon nga ang uso na is the annual paid time off, no? So kino-consolidate na nila yung VL and SL. That can also be something that you may want to consider kasi yung iba sabi paano naman yun, di man ako nagkakasakit, no? So paano naman? So yung para tapos yung iba naman paano yan pag na-opera ako 15 days lang yung sick leave. So yung ibang organization ngayon ginagawa na nilang consolidated na. So they just call it annual leave. I would like to know if, based on your knowledge, there is a big disparity of the rules of DOLE with that of CSE when it comes to labor relations. Of course, ang kaibahan lang, ang alam kong kaibahan, no, of course, is when you talk about employment sa Civil Service Commission kasi, di ba, meron tayong certification, yung civil service eligibility that you need to acquire, no, para magkaroon tayo ng para mag-consider tayong regular. But when you talk about yung mga formation ng union, yung ibang terms and conditions naman no are also the same, pero sa government kasi 40 hours work week tayo. 40 hours work week yung ginagamit natin. If you're familiar with Prime, no, yung Prime, it's the trust of the government to promote best practices in human resources as well. When you look into it, the approach is very similar to the private organization. So yun lang talagang hiring and regularization, no? Yun yung, and then of course the promotion kasi may mga eligibility requirement ang government that we need to be mindful of. The present daily wage is actually different per region, no? So you need to check the regional minimum wage rate, and then you also need to check kung meron bang COLA or wala bang COLA, no? Is it okay to pay all the unused VL or SL? This will now be up to the organization's trust, no? Pero I always, because I also, how do I call it? I also facilitate certification program no for compensation and benefit, and I always ask them the concept of no you also need to check whether the company where do you want to play in the market. So do you want to be within the market, ahead of the market, or lagging, and at the same time can you afford it? Because one thing that you need to be mindful of when you talk about benefits is not just the affordability but the sustainability. Can you sustain paying the unused leave time moving forward, no? So you also need to be mindful of that because I have an experience in the past nung 50 pa lang yung employees ng company before I joined, no? So they pay all the unused leaves. Naging 800 kami. So hindi na magiging beneficial to the company. So kaya as early as nung nag-100 kami, knowing that may projection kami to hire at least 800 people, so nag-start na kami mag-grandfather benefit. So that's why you also need to be mindful of the actions kasi incumbent kasi hindi tayo pwedeng bigay bawi eh. Lalo na pag 4 years na in the implementation. So unless mag-grandfather benefit, and it will cost a lot of communication to the employees, no? So kaya be mindful and make sure that you are able to check or weigh in, no, or strike the balance. Ano ang dapat gawin kapag ang employer ay nag-hold ng last pay resigned employees because hindi daw nag-turnover ang resigned employee kahit nag-render naman ng 30 days? That's the reason why you have the employee clearance. So in the employee clearance, that's why you need to inform the employee that they need to facilitate the handover, no? Okay, but you also need to take note, no, na meron ng ruling with regards to final pay, that the final pay must be released within 30 days as well. Okay, kaya dun sa 30-day notice kasi na employee, yun yung opportunity para magkaroon ng proper transition, no? Or magkaroon ng proper handover. I think same question, ano? Here in my office, we have JOs since they do not have employee-employee relationship as they are contracted employees. Are they covered by DOLE when it comes to their rights, even if they're being paid by our office, which is a government agency? I think for the government agency, when you talk about JO, so it is considered acceptable practice. So if it's in the government. Regarding companies filing for retrenchment, how would DOLE safeguard the rules so as to prevent abuse? Some companies file for bankruptcy, pero mag-change lang pala ng mga tao. Change name, avoiding formation of union. Again, no, sabi nga natin, when you close the business, when you open it, within the 12 months, ang priority pa rin is yung mga inalis mo na. When you retrench, tapos nag-hire ka uli within 12 months, so yun, sila pa rin yung priority nyo. That's the protection that is being that is being accorded by by the Department of Labor with the employee. Pero pag nag-change ng name ng entity, it's already considered kasi a different entity kasi 'di ba, especially if it's a corporation is it has a legal personality. So each corporation has its own legal personality. So, both SIL and VL at the same time, it's actually your prerogative if you wanted to, no? Although my experience in the past is when the company provided for VL already, integrated na doon yung kanilang service incentive leave, no? So, kaya okay lang. Ngayon nga ang nakikita kong trend is more about annual leave. So consolidated na yung VL at saka yung SL, no? And they let the employee manage it na lang kay kung paano nila gustong gamitin yung kanilang annual leave. Okay, anyone else? Okay. Do we have any other comments? Okay. Okay. One of the employee, ay sorry, let me just read para meron akong na-overlook. Wait lang. One of the employee assigned to a complex unit and he becomes stressful and submit to psychological help and advise the top level management to transfer the employee to less stressful area. Yeah, that's actually allowed, and it's actually if the company can allow it, if pwede naman natin silang i-transfer um to an area where they can perform, that would be good, no? Kasi yung in terms naman of, sabi nga natin, yung physical health, no? So, kasama din dyan sa, pag halimbawa, especially in my experience before in manufacturing, kay pagka hindi nila, yung health nila nag-deteriorate, so we also move them to other functions that are capable of doing para hindi naman ma-affect agad yung employment nila. So, hindi naman laging medical retirement agad yung gagawin natin. We also need to look into the we also need to look into ways and means on how we can move employees. Regarding shift schedule, okay lang po sa employee, 8 hours per day, including 15, and yung iba na, pwede naman yun, oo. Kasi di ba sabi ko nga sa compressed work week, ngayon kasi because of the changing in the business operation requirements, iba-iba na eh. Meron tayong mga employees na 9 hours, meron tayong employees 8 hours. When I used to be in manufacturing, yung aming mga office-based people, 9 hours sila kasi yung 1 hour meal break nila unpaid. Pero yung aming mga manufacturing employees, no, tuloy-tuloy kasi sila. So, naka-staggered work shift break sila. So, 30 minutes lang yung lunch break nila. So, paid yung kanilang lunch break. Any comment about the boss always telling the employee to sign the reassignment or you resign? Okay. So coercion or harassment is not tolerated by the law. So we can convince. Okay, so of course we can advise the employee then if it's a managed, if sabi nga natin kung wala namang restriction no in yung management prerogative, we can advise the employee that the company has the right no or has the prerogative to transfer work assignment, and then we can explain to the employee what would be the arrangement no or how you can help them in terms of the relocation, or how would this help them in terms of their career advancement no. So but let's not threaten our employee, it's actually not allowed no. Nasa batas po ba ang hazard pay? Yung mga companies, wala akong nakitang provision ng law when it comes to hazard pay. But may mga organization na nagbibigay ng hazard pay. For example, like hospitals, no, may mga ibang hospitals na pagka yung ibang staff nila ay exposed to different areas, no, dun sa mga sensitive areas, they extend hazard pay. Sa manufacturing, bihira ang nagbibigay ng hazard pay. For example, for me, no, half of my career is with manufacturing. My mindset is that instead of giving hazard pay, let us work on engineering controls on how to make sure that we have a safe and healthy workplace. Okay? Because yung hazard pay, so dinoto, ano lang yun eh. So you are just compensating pero you are not eliminating the hazards. Separation. It is usual practice to hold the pay of employees for one cut-off. Can the management decide to hold two cut-off or one-month pay? We have cases that separated employees do not respond when we attempt to retrieve company-issued materials and equipment. Actually, it's a management prerogative. You just need to make sure that your employees are aware of the policies, no? Okay, so that they will not file a complaint against you. It is also part of the employee's responsibility to turn over company assets. Actually, ako nasusurprise din ako ngayon kasi madami talaga mga employees ngayon na hindi nagsusoli ng mga company assets. So my suggestion is first remind them no accept their resignation and remind them of their obligation or their responsibility to turn over the assets because these are considered company assets, and then if they don't, you can issue actually a demand letter because yung hindi pagsusoli ng company asset, it's considered theft no. So you can also impose that. Yung management decided na hindi na kami mag-duty during holiday season for non-days but charge to VL. Marami po nag-negative dahil ubos na tuma, if there is meron kasing tinatawag ng company holiday na talagang stop yung operations ng business kasi wala namang gagawin, and then that's the time that they are asking their employees no to use their vacation leave. So um kung tama ba yung decision ng management ninyo na magpa-break during the holiday, hindi ko kayang sagutin kasi I'm not into your business operations. But in general, yes, ginagawa siya ng madaming company no and pinapa-charge. Yung ibang organization, what they do para ma-cushion yung impact to the employees is ina-advance nila yung leave for 2022, pinapagamit na muna nila para hindi mabawasan, or ginagawa nila, hindi agad nila ine-effect yung deduction ng one time. So parang ina-apportion nila, no? So siguro yun yung mga sabi ko nga kanina, what management can do to reduce, no, the employees' pain points, no? But definitely it's part of their prerogative in terms of legal context. Okay, meron pa po ba akong hindi pa nasasagot with regards to the chat box? If ever na na-overlook ko, paki-repost na lang, no? Kasi baka pag push ko lang nung screen is okay. So by the way, no, in our concept, there is no such thing as diminution of benefits, no? Yan. So kaya yun yung sinasabi ko lagi na but we have to be mindful. So you can change the benefit provided that you will be replacing it with a new one with of the same value or of superior value, no, to the employees. Okay, meron pa ba tayong questions? Okay. Okay. I think I have not seen any question to Ma'am, yung sa shift schedule po na question, same position and same na nasa operations department. Yes, pwede naman. So, ang importante lang dito, bakit magkaiba kayo ng work shift? So, yung bang 9 hours kasi meron bang may break time ba? So, yun. Pwede naman yun. Kasi syempre business requirement, bakit natin iniiba? Although, ang karaniwang nakikita natin is pag pare-pareho ng nasa operations, pare-pareho ng schedule. Pero meron din akong mga businesses na magkakaiba yung kanilang work shift schedule kahit pare-pareho sila nasa operations. So pwede pong hindi ibigay ang final pay ng resigned employee if hindi po sign completely ang clearance form. What if na-inelevate po ng resigned employee and concern sa DOLE and NLRC? Actually, ito yung concern ngayon yung sa final pay. I can share with you two insights, no? Ang aking personal insights dito, kailangan cleared yung employee bago natin i-release yung kanilang mga mandatory benefits, no? So ngayon, kung if after dahil meron tayong final pay, the DOLE kasi and NLRC is pushing for people to release the final pay. So para hindi kayo ma-hold, no, do sa 30 days, para hindi kayo ma-NLRC. So kung hindi sinoli yung mga gadgets ninyo at idedada, ilagay nyo na yon as part of your deduction. So para makita ninyo na hindi cleared yung employee, then meron pa silang obligation sa inyo, and then give them the letter, no, or notice that they are not cleared. Meaning they are not cleared and they still due you. Para kahit pumunta sila sa NLRC, may papakita ninyo na wala kayong i-release na final pay kasi sila yung may obligation pa sa organization. So, kailangan lang maipakita natin. So, sinasabi naman doon, hindi naman take away na dapat makuha nila. Kasi kung may may obligations yung employee, pwede nating i-deduct. Is 2 p.m. to 10 p.m. schedule allowed? Or is it pwede yung 2 to 10, pwede din yung 2 to 11 with 1 hour break. Yung 2 to 10 na schedule, kung ang break ninyo ay 30 minutes lang, paid siya. Yan, paid siya. Kung 30 minutes lang yung inyong break sa 2 to 10 p.m. na schedule. Okay. Any question further? Okay, may question pa po ba tayo? So, my suggestion to you, no, is the HR professionals, no, are familiar with the basic labor relations, but I also suggest that you also orient, no, your leaders, your supervisors, your managers, so that you are on the same page when it comes to managing people. And at the same time, no, sabi nga natin is, yes, we need to make sure that we understand the concept of law, but it will also be good to be sabi nga natin is to be creative as well in terms of kung pwede naman to go beyond what is provided for by the law, no, if it can reduce employees pain points, if it can lead to employee engagement, no. So yun yung sinasabi ko lagi. So and while it's good to understand the legal concept, it would also be good to focus on how to engage your employees, no, so that they would be motivated and they will continue to be productive. Okay. Any further questions or comments? Okay. So probably I'll just count up to 10, no, to check if there will be further questions in the comment section. So 10, 9, 8, 7, ayan, 6. Regarding absenteeism, if one day lang po ba, pwede na ma-charge na awol? Oo, lalo na kung nasa company policy nyo. Yes, pag hindi nag-file ng leave, kaya hindi pumasok awol, pwede na siya. Yan, pwede siya. Yun ay considered na absence without official leave. Okay. 12. But again, no, due process pa rin ha. Yan, kahit nga sa performance, due process we have to observe. Okay. 10, 9, 8, 7, 6, 4. Pag Sunday work, rest day work po. Okay, wait. Pag yung Sunday ay part ng regular shift, hindi siya rest day work. Pero pag yung Sunday ay considered rest day tapos pinapasok nyo, rest day work sila. Yun. Pagka yung Sunday ay hindi rest day work, tapos hindi pumasok, yun, considered kasi yung regular day eh. Rest day niya. So ni-require ninyong mag-overtime. Hindi nyo pwedeng, hindi pwede eh. Kasi rest day nila yun eh. But actually, what companies do, no, is that they get commitment kung papasok. They are asking people, oh, will you be working overtime for today? Then pag pumayag, no, then hindi nila chino-charge ng awol, pero nilalagay nila sa insubordination kasi you agree and then you did not opt to present yourself. Yan. Kasi rest day nila yun eh. Yun. Pero dahil nag-commit sila, yan, pwede yung insubordination. Yan. Mas matindi yung penalty, yan. Yan. Importante lang is maguhanin niyo yung commitment. Okay? Yan. Meron pa po ba? Okay. So 10. Again, bilang uli ako. 9, 8, 7, ang 30 minutes po ba pwede ma-claim? Actually, management prerogative yan kung saan magsisimula yung overtime. Merong mga organization na simula ng overtime minimum of 1 hour. So pagka less than 1 hour, hindi kino-consider na overtime. Yung iba naman 30 minutes. So yan ay management prerogative. Pwede rin yung pagfa-fraction. Halimbawa, kung 1 hour and 15 minutes, 1 hour lang. Kasi ang fraction is every 30 minutes. Sa inyo din yon, management prerogative din siya. Yan. So, kaya it would be good to specify, lalo na pagdating dun sa inyong pay practices, yon. Then, lalo na pag nag-ano sa inyong pay practices, ilagay nyo na yon kung paano kayo nagko-compute at nagbabayad ng overtime premium para clear siya. In fact, yung ibang mga organization, pati yung halimbawa, kung sa gabi yung overtime, pag nag-overtime ng beyond, for example, from 7 p.m. up to 10 p.m. So, binabawasan nila ng 1 hour to account for the break, to account for the meal break. Yun. Dapat lang yun nasa pay policy ninyo. Ayan. Okay. Any other question? So, ito yung mga paano tayo magbabayad. This is part of our management prerogative. Happy New Year, everyone. Will it be considered insubordination if chose not to answer a call from employer during rest day holiday? Okay. Management member or hindi? Pag management member kasi, syempre 30, sila, on call talaga sila. Pero pag hindi eh. Tsaka kasi meron talagang mga employees that they respect their rest day and their holidays. Pero pag nagiging frequent naman, tapos management team member, you can call their attention. Bakit po sa NCR may pay ang holiday ng mga COS samantalang sa province hindi? Ano yung COS? Sorry ha. The implementation of the law is the same regardless of the location. Ang magkaiba lang ay yung minimum wage rate natin. Doon tayo nagkakaiba-iba. So can I ask lang siguro, contractuals, hindi, they are also entitled to holiday pay. So again, pag regular holiday, kung daily or monthly wage earner, parehong may holiday pay kasi regular holiday. Pag special holiday, kung monthly paid employees, bayad sila ng holiday, no? So, pagka naman daily wage, pag hindi sila nag-work ng special holiday, wala sila ng 100%. Pero pag nag-work sila, meron silang 130%. Yan. Okay? So, meron kahit contractuals, no? Ang argument, company issued phone. So, maski naka-VL, weekend, need sagutin ang tawag. Oo nga, no? Pero, ako kasi, ang mindset ko din dyan, kung management people, yes eh. Pero pagka hindi kasi management people, siguro you need to specify dun sa provision kung bakit tayo nag-issue ng company phone. Pero kung sila entitled sa overtime, pag sumagot sila, then you also need to be mindful na pwede nyo silang magbayadan ng overtime pay. With double pay po ba ang mga seasonal employees? Whatever is the entitlement given to kung ano yung provision ng law, applicable din yun sa any type of employees, no? Pagdating sa mga holiday premium. So, ang pinakakaibahan lang, yung sinabi ko sa inyo kanina, when it comes to monthly paid and daily paid employees. Ako kasi ang suggestion ko dito, ilagay ninyo sa provision ng pag-issue ninyo ng company mobile phone that they are obliged to answer. But ang mahirap kasi ano yung striking a balance kung kailan ba tayo reasonable or not. So, minsan kasi kahit hindi naman ganun ko urgent is nagcha-chat tayo, nagte-text tayo kahit weekday or weekend or holiday. So siguro dapat din i-qualify natin. So pag sinabi natin they need to respond, so under din the premise na yun ay emergency and urgent. So yes, oo. Pwede naman. Yan. So ang importante lang is pag kinausap niyo sabihin niyo agad na okay, hindi ako tatawag sa iyo pag hindi matter of life and death or pag hindi urgent, hindi emergency. So I am expecting you to respond kaya you are provided with a mobile phone. Pag HR people kasi parang expected sa atin eh. So that's why I always tell na yan. Ay, me time, oo. Tama ka, Clarissa. Sasabihin nila me time. Oo. Pero hindi pwedeng all the time. Hindi sila sasagot. You need to call their attention. Yun to yung pwedeng counseling muna. Tapos pag nagiging rampant na hindi talaga sila sumasagot, then that's the time that you need to remind them, di ba? Then pag lagi niya nakakausap, hindi pa rin, then you can proceed na. Tama. Tama, Maria. Doctor on call ang HR. Yes. Okay. Pag HR ha, we are considered management personnel. Kaya kung HR people nyo yung hindi sumasagot, hindi pwedeng sabihin hindi sila management personnel. So they are considered management personnel. And by the way, no, especially with the work from home concept, yung may work from home na tayo ngayon, may work rotation na, work-life integration na eh. Talagang nagsasama na siya eh. Kaya mas lalo nating nadadrive ngayon na sumagot yung mga tao natin kahit beyond the working hours because of the work-life integration concept. So, even naman in my corporate world, no, during my corporate world, I always tell them na um, parang our role no in HR is evolving, no? So, in fact, we'll never know kung merong mangyayari emergency. So, and that's the reason why we are provided with mobile phones. So, if you are not able to respond agad, then please return call, okay, or text, no? Because it may be urgent and your help may be needed, no? Okay. Okay, 10, 9, 7, 5, 4, 3, 2, ayan. Okay. So I think we don't have further questions. I hope you have enjoyed our session for today, no? And and if you have further questions, you may want to reach out to Limitless Power Coach and so that they can connect you to me, no? And I hope you found it insightful as we always have mentioned nga, no? It would be good to make sure as well that our frontline leaders, especially our supervisors, no, are very familiar with uh, with people management, no, in terms of disciplinary action, managing employee complaints, no. So if you would like to orient them, please feel free to reach out to Limitless Power Coach. We do facilitate in-house programs, no? And for in-house programs, we also provide business cases, yung mga Supreme Court rulings talaga, no? Yung dinidiscuss namin so that yung practical application ng ating mga leaders, no, is mas ma-enhance nila or mas ma-harness nila because they really are the one involved in facing our employees, no? Especially right now, the the business landscape is evolving from the face-to-face interaction, nagiging hybrid na tayo with face-to-face and online. So the concept, no, are also changing. So it would be good to onboard them, no, and make sure that you HR and your operations people, your frontline supervisors or frontline leaders are on the same page as well. Okay, and also if I may plug, no, you may want to reach out, no, to Limitless Power Coach. I would be having a paid webinar naman ito, no, on January 25, if I'm mistaken, no. On January 25 about leading strategic growth, no. So it's a 4-hour webinar wherein I will be discussing. So if the company is in the process or is planning to set up your strategic planning session, or is planning to create a strategy for the organization, kasi 'di ba, because of the pandemic, ang dami ngayon is going back to the drawing table and discussing and outlining what would be the strategy for the organization. So if you would like to hear thoughts, insights on how I do it or how I roll it out with clients, no, you may want to register, no, and we will be discussing with you a 4-step approach in creating a strategy that works, no, and in making sure that your strategic planning, your strategic plan will be converted in not just into ideas but into actions, and we would be able to measure the results, no. Okay, so with that, I thank you very much, everyone. So it's nice to see around 60 participants in the room. So thank you very much, and thank you, Limitless Power Coach, for inviting me over, no. So probably I was not able to give a caveat a while ago. So I'm not a lawyer. So the thoughts and insights that you have heard from me is based on my 25 years of experience as an HR practitioner, wherein 15 years of which was in a plant setting. No? So which is why I've been very heavy on basic labor on I've been very heavy on labor relations. But one thing that I would like to share with my fellow HR professionals in the room, no, is that it would be good to understand the legal concepts. Okay, but of course we need to be mindful in terms of integrating it into employee engagement, because what matters most is, especially at this time, is to make sure that our employees would be motivated, no, would be highly engaged. And because sabi nga natin, if employees are motivated, they are engaged, so they are very proud of the brand, no, the company brand. They are proud of the company they represent. And we also know that people who are proud of the companies and people who are engaged and motivated are people who are more productive. So with that, no, magandang umaga sa ating lahat, and I hope nag-enjoy kayo the same way that I enjoyed our session this morning. Okay. So thank you very much, everyone.